Hi, everybody. We are starting. Can you all? Yeah, you can see us all. Great. I'm Carrie Brown. I'm the executive director of the Vermont Commission on Women, and I'm really pleased to be moderating this panel today. We have some incredibly knowledgeable and thoughtful and smart people who are going to tell us about some of the ways that Vermont has been addressing gender equity and hopefully will continue to. Um, the Commission on Women is, for those of you who don't know, we're a state agency. We're an independent agency, and our job is to provide advice and counsel to the executive and legislative branches about issues concerning women, girls, gender equity. And so we do that through research, through testimony, through public education, and through direct, people call us sometimes asking for help, and we point them in the right direction. And we've been around since 1964, and um, and I've been working in gender equity since 1996 in various capacities, and it's been really interesting to watch kind of an evolution of how much people want to talk about gender and how much they want to talk about sexism and how much they want to talk about patriarchy, and it really ebbs and flows. Um, but I would say that in my experience overall, it has been a little bit challenging to try to keep gender in the conversation when we're talking about equity. And it will kind of flare up like Me Too, great, people were talking about sexual harassment, fantastic. Um, but it's, to me, I really see like an underlying force of patriarchy is kind of under everything. And there's this, like, it's like a tide or like a flow or something that's just sort of there. And it informs a lot of other things, I would argue, like white supremacy and imperialism. And it's like a constant sort of force trying to keep women away from power in various ways. And so the three folks who are here today are going to talk about some of the ways that Vermont is kind of recognizing that and looking at it. And so we have Emily Adams from the Civil Rights Unit of the Attorney General's Office, who can talk about harassment and discrimination at work. And to me, this is one of the ways that women have so much more access to the workforce now than they used to, and they still have to contend with sexual harassment on what seems to be an incredibly widespread basis. And the number well, I mean, I'm sure you all know this, but that the small kinds of harassment that happen that people just accept as, oh, this is just day to day, or the equal pay. I've got my equal pay T-shirt on. The equal pay violations that people don't even really realize are happening. And then Jessica, who's online, Jessica Barquist is from Planned Parenthood of Northern New England. And she's going to talk about reproductive rights and about, what the way that I'm looking at this is that there's a constant desire to control women's bodies as a way to, and if you can control people's reproductive lives, you can have an influence over their work lives and their economic stability and the kind of opportunities that are available to them. And then Alita Sprague she's a member of the Vermont Commission on Women, and I'll let each person just, tell us a little bit. You can tell a little about yourself when you get up. But Alita's going to talk about the constitutional amendment that's currently in the legislature and being considered that I call an equal rights amendment. Other people call it different things, but it's an equal. It grew out of, remember, law way back in the 70s, the ERA that never made it through at a national level, and then in the 80s there was an attempt to amend the Vermont Constitution, and that didn't work either. And so now we have one that is broader than just sex discrimination, which is great, includes all kinds of other discrimination. And this is a way to address the kind of fundamental ways that we have built systems that are trying to keep certain people out of power again. And so looking at the Constitution to amend it as a way to address that. So the way we're going to work today is each person will go and have some time to talk to you about the work that they've been doing, and then we'll have some time for questions at the end. All right? Okay.
Great. I'm gonna
Oh, yes, and
jump over here.
they have slides, so they're going to hit up there.
All right, thanks everybody. I'm going to get my slides going, so just bear with me for 1 second. How's that looking? Good? Okay, great. So thanks so much. As Carrie mentioned, my name's Emily Adams. I'm an Assistant Attorney General and Co-Director of the Civil Rights Unit at the Vermont Attorney General's Office. Um, my role in our office focuses predominantly on our employment discrimination enforcement work, and so I'm going to talk a little bit about that today. I'm going to talk specifically, sorry about that, about sexual harassment in the workplace and what we've done in the area of enforcement there. But I will go over a little bit just more broadly some of the ways in which our state laws do protect various gender equity issues. And then in talking about sexual harassment, I'm going to spend a few minutes doing kind of a deep-ish dive in the short amount of time we have into one particular litigation matter that our office handled a few years ago. I think that was a good example of a success because, after all, we're here to celebrate kind of the successes in civil rights enforcement that our state has been able to do and to brainstorm ways forward. And so we'll talk a little bit about that one particular case. So my world largely revolves around just a couple laws, but the main law is the Vermont Fair Employment Practices Act, and that protects employment discrimination and harassment based on a variety of protected categories, and that's what you're seeing on your screen. I found it interesting that Carrie said that the Commission on Women has been around since '64, because for this presentation, I actually looked to see when the Fair Employment Practices Act was passed, and it looks like it was in '63. So the year before the commission came into being. And so many of these things are protected under federal law, but it's important to know, I think the ones that are starred on your screen are also protected under various federal laws, but Vermont has long been in the forefront of protections for workplace discrimination. And so we had sexual orientation and gender identity protections long before the 2020 Bostock decision, which solidified that those were also protected under sex discrimination. And no matter what any executive orders tell you, Bostock is still good law. And so we're going to focus today really on sex and sexual harassment, but this is the realm in which we do have protections for employment harassment and discrimination in Vermont. And then a couple of other laws that protect women employers or folks who identify as women in Vermont. We have protections for nursing mothers in the workplace that allows, or rather requires, nursing mothers to have a clean space other than a bathroom to express breast milk for several years after the birth of a child. We have various equal pay laws on the state and federal level, and those have been expanded in Vermont in recent years. Pregnancy accommodations laws, family leave laws under state and federal law. Most recently, the Pay Transparency Act was passed this last summer with an ultimate goal of, I think, sort of starting to level that playing field from past inequities in pay. And then we have flexible working arrangements laws, which allow employees to seek additional flexibility in their work scheduling. Again, that often can be helpful for women and in particular mothers or those caring for others in their family. So this is just kind of the broad realm in which, again, kind of the rules to the work that I do all fall within these various laws. So I came to this work. I was in private practice for about 5 years after law school doing employment work. And in January of 2018, I joined the Attorney General's office. This picture is me, but it's actually a little bit of, for me, it's a little bit of a joke because my first week of work was the first week of January in 2018. And that was the week in which the Vermont legislature announced their intent to pass this kind of sweeping Me Too related legislation. And I think it was like my third day of work, and my then boss at the time said, "We're going to have you speak at this press conference about sexual harassment legislation." And that picture made it into Digger, for better or worse. And so when I was kind of going back to research those changes at the time, this picture actually popped up, and I thought, I'll kind of humor myself and add that in here. But in any event, history matters for these things. And so, like Carrie was mentioning, there was really a moment, and that was, I would say, probably 2017 to 2018, where the Me Too movement was happening nationwide, globally, and Vermont, like many other states, sought to um, create change in the sexual harassment realm, particularly workplace sexual harassment. And so a couple things happened as a result of that legislative session. There were a lot of proposals that were thrown about, but ultimately, the law in particular with regards to sexual harassment was expanded to cover anyone who engages a person to perform work or services. So that's broader than your traditional employment relationship. That can be contracting, internships, those types of things. Um, it added additional terms under which employers can settle sexual harassment claims. There was a prohibition on what we call no rehire provisions, meaning when you have a settlement, they can't say you can never come back to work for this employer, along with some other required language that was intended to really have folks settling a sexual harassment claim understand their rights and what they were actually settling. And it created an audit function for enforcement entities, which I'm going to circle back to at the end of this. But the ultimate goal of that was that maybe we don't have to have all of our enforcement be complaint based, but there can be sort of a, like you see the Department of Labor doing at times, where they go in and audit workplaces to see if workplaces are truly meeting their obligation to prevent sexual harassment in the workplace. So all of this went into effect in July 1st of 2018. And there was, I think, really huge goals and intents to change the workplace with regards to sexual harassment. We also created a little fun informational video with the help of WCAX around that time, which still exists on YouTube, I think, regarding workplace sexual harassment. Carrie was part of that group. And then any guesses as to what happened shortly after in the realm of history? COVID happened, right? And a lot of our kind of focus and shift really changed. The idea of in-person audits was not something that we were able to carry out at that time. The legislature really changed their focus to things other than workplace sexual harassment. And so the moment shifted, and I think, in my view, there was a little bit of a stalling out on some of those efforts at that time. But I was very excited in 2021. An opportunity arose for our office to get involved in litigation around workplace sexual harassment. And this was really, for me, an opportunity to get out there and really maybe publicize some of the work we did, and also start to do some education in the area of workplace sexual harassment in a more public realm. I'm going to talk about a case that I want to acknowledge the underlying facts of this case happened just a few miles from here in Randolph. Everything I'm going to talk about today is in the public record. I pulled this from court filings, from news stories. So this is not anything that, as an attorney involved in this case, would be something that I know or that is confidential in any way. But it is sensitive, like any of these cases that may happen. They do affect our Vermont communities and folks that we may know. But the case was called EEOC versus Coughlin Inc. There was two other plaintiffs, a woman named Jenny Lumbra and also the state of Vermont. And what essentially happened, and I want to keep an eye on my time, okay. What essentially happened here is the EEOC sued in federal court a local McDonald's franchisee, alleging that at a McDonald's store that there had been a particular manager who had engaged in systematic sexual harassment of young workers over a period of at least 5 years. This entity owned about 10 to 20 McDonald's across Vermont and New Hampshire, so small business by nationwide standards, but not by Vermont standards necessarily. And so we became aware of the EEOC's lawsuit happening here in the state of Vermont. And we actually became aware of the fact that our office, several years prior, had already sued the same entity for sexual harassment at a different location. And so we intervened in the case as a state, seeking civil penalties for violating a prior agreement we had with them not to engage in further sexual harassment in the workplace. I apologize for some of the kind of language here, but the allegations of the complaint were pretty severe. Again, this was conduct that happened over the course of at least 5 years. We suspected longer. And it was really, if you picture a McDonald's kind of fry a later line and the work line, it was um, touching body parts, commenting on body parts. Most of the victims here that did come forward were high school aged. Many of them were minors or young adults. And these are the type of folks who didn't have much of a choice. They needed these jobs to support their families. Some of them were houseless. And it was a situation where many of them told us, like, we didn't even really know this wasn't okay. It was my first job. This is just how people acted. And so it was, a pretty clear, not just one victim type of case. There was numerous folks affected here. These are facts from the court complaint, but what did happen when this particular one employee who came forward, who was actually a little bit older and had had other jobs in the past, when she complained of the sexual harassment, she was written up for quote unquote, the perpetrator was written up for horseplay and suspended for about 3 days. But then the individual herself who complained, a reasonable accommodation she had in place was revoked. Again, these were her allegations. They revoked that reasonable accommodation for a flexible schedule and retaliated against her with other disciplinary actions against her after she complained. So again, the state intervened, basically alleging that this employer had engaged in this conduct previously, and also that this was in violation of state discrimination laws because the EEOC was enforcing federal discrimination laws. And under state law, we can seek financial penalties, which is not something that the feds can seek under federal law. We went into quite the process of litigation. For those of you that know what litigation is like, this involved numerous depositions, lots of documents being exchanged over about a year period. Unfortunately, the individual who had complained of the sexual harassment and initiated this whole suit, she passed away during the pendency of the litigation and was not available to testify. But ultimately, we were able to engage in, enter into a resolution with the employer. From our office's perspective, as far as we know, this is the largest reported sexual harassment settlement in the state of Vermont's history. It's very likely there's been private settlements that may have been larger than this, but in terms of a public settlement, it was a $1.6 million total settlement. $1.2 million of that went to a class settlement fund for the victims of that harassment. That was administered by a third-party kind of fund administrator, but we know that at least 40 victims were verified through that process, individuals who had been affected by this harassment, and were able to obtain some of that class settlement. $275,000 to the estate of Jenny, who was the individual who had initiated the suit in the first place, and $125,000 were paid in state penalties as a result of our intervention. Currently, we're still in the process of a 5-year consent decree that is enforced jointly by the feds at the EEOC and our office, which means that we are monitoring their compliance with various terms. The employer has to maintain a 24-hour hotline and have an independent compliance monitor that basically checks in with them regarding any complaints they have about sexual harassment in the workplace. They have to conduct annual training. There's a whole slew of things. These are just a few of them. It's like a 20-page document you can find online. But it's a pretty significant, fairly long as these things go, consent decree that this employer is engaged in with our offices. And that's for all of the restaurants. That's not just the one location in Randolph. That's for all of the McDonald's owned by this operator. So not McDonald's as a whole, but those stores, which I think is 10 in Vermont, owned by this operator. So in brief, because I want to give my co-presenters time too, but these are just some thoughts that our office has continued to look at since that resolution of that suit. How do we reach those entering the workforce, those new folks who don't even necessarily know or understand what laws protect them, what retaliation is, that there's a protection for retaliation? does the law sufficiently cover ambient sexual harassment? And what I mean by that is a lot of what we learned about in this case were individuals who maybe they weren't the target of the touching, or even the words weren't directed at them, but they lived in fear of going to work because of the pervasive harassment around them. And, this settled. We didn't go in front of a jury to make a decision on what is unlawful harassment, but it was our position that being a victim of that ambient harassment was also covered by the law. And then what industries are really hotspots or are kind of incubators for sexual or other types of harassment? Is there areas we should be focusing on? And where can the state make the most impact? The reality is we don't have a lot of resources for enforcement. Are there ways that we should be targeting our enforcement to really make significant impact? I'm not going to go into this in depth. I think Carrie touched on this on Friday, but one good stride since this time, since the suit resolved, was an expansion of the definition of harassment under state law in 2023. So harassment now has its own state-specific definition, which is, I think, covers more than it did under the prior interpretation of federal law that was then applied to Vermont law, which would cover more of the harassment that we're talking about in this case. And just to circle back, what's happening for what our plans are in enforcement in the future, we are finally going to dive into those audits. And so I mentioned back in 2018, we were given some authority to conduct workplace audits, which means that we can look at records and processes that employers have in place regarding sexual harassment. We can look to see if they have, yucky posters on their walls or anything like that. This is something that our office will be rolling out in the next couple of months officially. It's been long delayed, and we're excited to get that rolling. We anticipate this will be random audits, but likely industry focused. So we may have a focus area at a given time based on industry, where we then randomly generate the names of several businesses that we do audit. If you want to jot down any of our contact information, it's right here. That's my personal work email, but we also have a civil rights general email and phone number that anyone can call or reach out at any time with any questions to our staff. So that's just a little bit about the work we've done in the realm of sexual harassment, but happy to take any questions probably at the end. Yeah.
Thank you so much, Emily. So we will next move to Jessica Barquist, who is online. And there you are. Hi.
Hi, everyone.
Go ahead and tell us a little bit about yourself and the work that you have to share with us.
Yeah, I just submitted a request to share my screen so I can share my slides as well. Okay, looks like I can do that. Give me 1 second. Okay, can you all see my slides?
Yes.
Awesome. Okay. Hi, everyone. I'm Jessica Barquist. I use she, her pronouns, and I am the Vice President of Public Affairs at Planned Parenthood of Northern New England and the Planned Parenthood Vermont Action Fund. Okay. So at Planned Parenthood of Northern New England, we really think about reproductive justice as kind of the framework for our work. So yes, we advocate for abortion rights and access to reproductive freedom, but there is so much that is encompassed in that. And essentially it is really the right to decide what to do with your own body and the right to have a child or not, and to be able to make all of those choices, which includes financial choices as well, right? Like the right to housing and healthcare and the ability to provide for the family that feels right to you. So reproductive freedom encompasses a lot of what we do. So we talk about things like contraception. We talk about access to birth choices. Last year in the legislature, we worked with a coalition around the right to have birth centers in the state, so that there is more, options for individuals who are giving birth other than just a hospital or home birth. There's that kind of middle ground of a birth center as well. And then, making sure that there is family planning access for everyone, including LGBTQIA plus families. Right now, as I'm sure most folks are aware, the ideas of reproductive justice and reproductive freedom are under attack, primarily from our federal administration. And I could spend all day talking about each one of these individual bullet points and what it means and how it intersects with Vermont law. But I think the essential, like the broad overview here is really that reproductive rights and justice are being attacked from all three branches of our government. And it's really a concentrated and intentional plan that was outlaid within the Project 2025 document. And so we're seeing these rights being stripped through the executive branch with administrative orders. A lot of those executive orders have been around gender affirming care and particularly for minors who are choosing what to do with their bodies and what those right medical choices are for them. So we are seeing some gender affirming care bans in terms of healthcare coverage. And some trans education and sports bans. And a lot of this is coming out of an executive order where President Trump defined their gender ideology as two binary genders. And so I will just say that a lot, if not all of these executive orders are being challenged in courts right now. And the vast majority of those challenges are winning. So even though these things are out and they can be really scary, there is some hope there in that the courts are actually doing the right thing and not upholding these executive orders. Which brings me to the courts, because not only are they dealing with the lawsuits around a lot of the executive orders and the bills that are passing in Congress, but they also have a few of their own challenges that they are navigating through. So we are seeing a lot of challenges again around gender affirming care and Medicaid and like the funding of healthcare and whether or not we should fund reproductive and sexual health care. And this is really intentional because, as I'll show you in a later slide, right, reproductive rights are very popular, not just here in Vermont, but really across the country. Folks really believe that everyone should have the right to make decisions about their own bodies. And so they found that restricting care through restricting rights wasn't really working very well. And so the new framework in this new administration is really trying to restrict access by restricting funding and preventing folks from being able to access that care, even if they have the right to it. And then that's true in our third bucket here, the third branch of government, Congress, HR 1, often called the Big Beautiful Bill. I have a hard time calling it that. There's a lot in here that strips healthcare away from folks across the country here in Vermont. But one of the things that happened right away was a Medicaid defund of Planned Parenthood. Which essentially means that while Planned Parenthood is a Medicaid provider, they can no longer get reimbursed for those services. And so that is a way that that they are trying to reduce individuals' rights to this health care by reducing that access to that care. So this is, all of these attacks together are, ongoing, and they're really intentional. They are really meant to target states like Vermont, where abortion and reproductive health care are safe and legal. And we're really seeing that that these attacks are coming from all three branches of government, like repeatedly at states really trying to restrict that fiscal access, so the funding for these programs. This is just a little bit of our landscape of what we're working with right now. So abortion access and policies after the fall of Roe with the Dobbs decision. And really proud that Vermont, we are one of the most protective, and I'll get into our policies in just a second. Um, but the landscape of the country is really challenging right now. 1 in 4 women of reproductive age don't have access to abortion where they live. And 1 out of every 5 patient who receives an abortion is traveling more than 300 miles to receive that care. So the landscape of our country is just really challenging right now for a lot of folks across a lot of places. Um, Luckily, we have some good protections here in Vermont, and the same is true for our shield laws, which I'll get into a little bit more. But those same states that have that access to care are also the ones that are passing the laws that are protecting patients and providers of receiving that care. If you look at those maps and then you look at the places where um, transgender healthcare and gender affirming care are being restricted, those maps are an overlay there as well. So that's kind of like the broad overview of what we're working with nationally. And now I'm going to get into Vermont. I like to get the bad stuff out of the way first, so then we can really dig into our strengths and where we can go, because there is so much good that we've done in the state of Vermont. So in 2022, Vermont was the first state to pass a constitutional amendment protecting reproductive liberty. And this passed overwhelmingly across the entire state. So 77% of voters supported it. No other state has had such high numbers when they've passed something like this. So it's really incredible. And that was true even in towns that overwhelmingly voted for Trump in the same election. So, regardless of where folks sit on the political spectrum, that core belief in bodily autonomy was really held throughout the state. And so, this amendment in our Constitution codifies our right to choose or refuse contraception, the right to choose or refuse sterilization, and the right to become pregnant and give birth or have an abortion. And so you can see that it really brings in that full spectrum of reproductive choice. People often talk about this as like, oh, it was the right to abortion. But it was so much more than that. And it was so much about that full spectrum of being able to choose for yourself what is right for your reproductive journey. Um, and so the state can't interfere with any of this. So this is really great. The being in the state constitution is like the highest state law that you can get, right? It's hard to get passed. It had to go through 2 bienniums in our legislature, so 4 years of our legislature working on this, and then it went to a vote in November of 2022. And so folks were across Vermont were able to weigh in on this as well. And so that's like it's a big process. It's really hard to get something like this passed. And as a state law, this is the most protective that it can possibly be. That said, federal law always supersedes state law. So even though we have these most protective laws in the state, if laws were to change federally, or Congress were to strip away some of these rights, that would supersede our constitutional amendment. But it does give our Attorney General's office a really good case to say that those federal laws are unconstitutional in Vermont and challenge those laws. So it's a really great thing for us to have, and other states have modeled their constitutional amendment and how they're talking about this bill off of what Vermont did. We were definitely a leader in this space. And then we have also been a leader in terms of shield laws. So shield laws came about with the fall of Dobbs, realizing that we needed to do a little bit more to protect both patients and providers of this legally protected healthcare that is codified in our Constitution. So in 2023, Vermont was among the first states to pass shield law legislation. And we expanded that from just abortion and reproductive care again to include gender affirming care and a really broad view of what that's called. And so now in our state law language, this is called legally protected healthcare. And so if you are a provider of legally protected healthcare or a patient of legally protected healthcare, Vermont is saying like that care is legal in our state. We are going to have your back. So other states can't then come in and pass lawsuits or criminal investigations against providers of this care in Vermont, as we're seeing. And we're seeing some of those challenges play out right now, particularly in New York, with some doctors there. New York also has some shield laws. And so we're kind of, when these laws were developed, they were very much developed in theory. And so the New York case is really the first time that we're seeing that shield law be tested and really play out in the court system. Because we were the first in 2023, their states have then passed shield laws. We saw that map earlier. And so through the other states passing those laws, we realized a few places where our laws could be strengthened again, and there were some gaps. So we passed an update to our shield law in this past legislative session in 2025. And again, this law had wide bipartisan support across our legislature. Folks really felt across the aisle, across the spectrum of where folks fell politically, that it was really important that we protect our patients and our healthcare providers in this state. So some of the things that we did in 2025 were we included a provision that allows folks to remove the prescriber name from a prescription bottle for medication, abortion, or gender affirming care. And that really came out of that New York Shield Law case, because in both cases, she was identified as the doctor from a prescription bottle that somebody had in their state. One of the cases is in Louisiana and one is in Texas, and both times she was identified by that prescription bottle. So that felt like a great way that we could protect providers from being named by other states. It expanded care for medication abortion to asynchronous care for telehealth. So that allows telehealth providers to be able to provide that care via an adaptive form on their websites, which is what a lot of the bigger national telehealth abortion providers do. And then this is something that we are kind of the first state to do. So our new Shield law offers reciprocal protections for providers who are practicing in other Shield law states. So a provider in New York or California who is practicing under their Shield laws can come to Vermont, can visit their family here, can vacation here, can be in our state, and rest assured that even though they didn't practice in our state, that Vermont is still going to uphold that. So as long as where they were practicing and it was legal there, we will offer that same Shield law protection to them while we're in our state. And I have since had conversations on a national scale with folks who are trying to do this. Other states have tried to do it as a state by state agreement. And Vermont just really did a blanket, like, no, regardless of where you are, we're going to protect you. And so this is really being seen in the national circles as kind of the gold standard for this reciprocity now, which really proud about. And it was just never a question in our legislature. Like they were like, of course, we're going to protect every provider who wants to be in our state. So really proud about how that all went down. And then our first Shield law had some provisions around advertising and truth in advertising, but they were really specific to one group of providers, which are crisis pregnancy centers, which are in clinics that are their goal is to talk folks out of getting abortions. And so these provisions were really targeted specifically at them. And in the 2025 update, we said actually all like trust and truth in medicine is the foundation. And so these laws should be applied broadly to everyone in the medical field, that there should be standards around truth in advertising and in the counseling that you get in a medical setting office. So those were expanded to include every single one of our professions. So it made the bill really long because there are a lot of different medical professions in the state. But again, one of those things that just felt like really cutting edge and also a no-brainer in some ways that like, of course, this is something that we want and we value in this state. As we talked about, birth control accessibility is another part of this, right? It's not just the one side of abortion and that, but really being able to access that full spectrum of healthcare. And so Vermont passed an access to birth control law in 2016. And this really codifies some of the Affordable Care Act birth control provisions and allows folks to access 1 year's supply of prescription birth control and access to long-acting reversible contraceptives as well. And so most of these are free, depending on who your insurance carrier is. Most of these are required, if you get it through the state exchange, to be free for Vermonters. So along with sterilization and other forms of contraception, and making sure that anyone of any age can obtain these without needing to go through additional steps of parental notification or anything like that. So these are great. And we're actually seeing since the elections last November, so about a year now, pretty much right after the election, we saw a huge increase in folks coming into Planned Parenthood for LARCs, the long-acting reversible contraception like IUDs and implants. And that has remained pretty steady since then. So for the past year, that has been a really big thing. And folks are able to use these benefits to get that birth control that they can set and forget and then not have to worry about it for sometimes years at a time. And then finally, we have some of the broadest minor access of any states. So minors can, without parental consent to abortion and STI treatment, as well as the birth control like we just talked about. And then we also have a law that requires Vermont schools in our secondary schools, so middle school and high school, to provide free condoms and menstrual products to students in schools. So folks can have access to that either in the bathrooms or through the nurse's office. And there are no restrictions in our state on access to gender affirming care, because it is that legally protected healthcare in all throughout all of our laws. And last, there's so much to talk about here. There's so much good, but just also wanted to lift up as we talk about reproductive justice, that includes the right to create the family of your choice and how you want that to look. And so really proud that Vermont is also out in the forefront of those protections for LGBTQIA families and the legal benefits around birth and adoption for our LGBTQIA families who choose to have their families that way. And I'm sure there's lots of questions, but I didn't want to go on too long. So I'm going to stop there. Thank you.
Great. Thank you so much, Jessica. I love all the good news. Good news is so great to hear. So we will take questions after everyone's done. So I'll pass it over to Alita now.
Great. Hi, everyone. I'm so glad to be here. My name is Alita Sprague. As Carrie mentioned, I'm a commissioner on the Vermont Commission on Women. I'm also the Director of Legal Analysis at the World Policy Analysis Center at UCLA. And I'm the co-founder of a new organization spinning out of UCLA called Equal Futures. What I'm going to talk about today are equal rights amendments in constitutions, what they are, why they matter, what one could mean in Vermont. And I do use the term ERA, talking about Vermont. I think it's descriptive. And I'm going to bring a bit of a different perspective than maybe you've heard in other presentations through this conference, because much of my work over the past decade has been globally comparative. So what we do at the center where I work is we look at laws and policies and constitutional rights all over the world in all 193 UN countries, and we try to draw lessons from what we're seeing in trends across the world, and put the policies and laws of individual countries in global context. So I'm going to start very big picture. I'm going to spend a little while talking about ERAs all over the world and what they've done, but I will narrow in on the US and eventually specifically Vermont, and hopefully provide some context for the proposed ERA here. Okay. So again, what a team at my center has done, we've looked systematically at the constitutions of all 193 UN member states to understand what rights they protect and the strength of those rights. So as you can see here, the US is a big outlier when it comes to protecting equal rights on the basis of sex or gender in its constitution. As of 2024, about 86% of constitutions globally had some kind of protection for sex or gender in their equal rights provision. And that includes virtually all recent constitutions. So every constitution passed since the year 2000, and that includes constitutions the US has advised on. So this is a global norm, and we recognize it as such in our foreign policy, even though adding the ERA to the US Constitution still hasn't overcome final political hurdles. And I'm happy to talk about that more if anyone is interested. The US also doesn't guarantee equal rights on other grounds with specificity. So the Supreme Court has determined over time what kinds of discrimination require heightened scrutiny, higher levels of judicial review. But that approach to interpreting the Equal Protection Clause has led to inconsistent levels of protections across different groups. So as just one example, I'd like to highlight from the global perspective, Supreme Court has ruled that poverty is not a suspect classification. So if there are policies or practices that distinguish on the basis of socioeconomic status, such as funding schools through local property taxes, generally that gets the lowest level of review. So it's really hard to find a policy like that unconstitutional or discriminatory, even if its design and its impacts are discriminatory in practice. But as you can see here, if we look globally, nearly 60% of constitutions do take some approach to recognizing that discrimination based on socioeconomic status is discrimination and should be prohibited. So we're behind as a country in our constitution, not just on gender, but across a range of other dimensions, which of course has implications for fully realizing the rights of marginalized groups. So again, I'm going to move through this presentation from the global down to the state. But before leaving the global, I wanted to just give a few examples from around the world of how constitutional guarantees of sex or gender equality have been used. And I'm going to highlight a few areas where the US also has room for improvement. So the first area is caregiving, and as probably most people in this room know, another area of unfinished business for gender equality in the US is paid leave. We're one of just 7 countries in the world without any paid leave for new mothers. And because we're such an outlier, what we see happening in the courts of other countries is not so much that their gender equality provision is being used to adopt a new paid leave policy, but more that it's being used to make sure existing policies are more inclusive, more equitable, that they cover all family types. So just a few examples here to show this potential. One case from Germany back in 2011. Basically, they have a parental leave policy where they give 12 months to a household, and if the parents share that leave, if it's not all just taken by the mother, they will get 2 additional months. So it's designed to incentivize more gender equitable sharing of leave and kind of shift norms. And that was challenged in court as discriminatory, but the court said, no, this is actually very consistent with our Constitution, which isn't just about formal equality, but about actually promoting gender equality in practice, more of a substantive vision of gender equality. A couple more recent cases in Spain, you might have seen coverage of this one in the New York Times. It did get some press, but there was a single mother who challenged their paid leave policy. There's 32 weeks that can be taken by a household with two parents. But if you're a single parent household, you only get half of that. You get 16 weeks. And the court agreed with her that this was indirect discrimination on the basis of gender, since most single parents are women. So now single parents in Spain can take that full 32 weeks. And then in South Africa, this case was just a couple months ago. So in South Africa, fathers and partners can take 10 days of leave. Mothers can take 4 months. And this was a case that was brought by a couple in which their mother was really the high earner. She had a very demanding career. The father was taking more of the lead on caregiving. And they said, we want to divide this leave how it works for our family. And the court said, yeah, actually, gender equality in our Constitution sort of compels that result. So now families in South Africa can divide that 4 months how it works for them. So for the sake of time, I won't go into these remaining cases in such detail. I think the caregiving ones are so interesting. But suffice it to say, in the area of violence and harassment, gender equality provisions have been a foundation for new legislation in places like Nepal and India, in areas including marital rape and sexual harassment. They've also provided a foundation for overturning discriminatory laws like laws that permit child marriage. And whenever I share this with the US audience, I just like to make sure people know that this is not a non-issue in the US. A majority of states actually still allow girls to be married as children. Thankfully, Vermont is no longer one of them after a bill was passed a few years ago, but national estimates suggest around 300,000 girls were married, or children were married, mostly girls, between 2000 and 2018, including some as young as 10. So this is another area where we are behind in some ways global standards, and ERAs can provide a tool. And lastly, I just want to touch on reproductive rights, because as we see the US nationally regressing on reproductive rights, much of the world has been progressing, especially in Latin America. There have been decisions by top courts in a number of countries that have cited core constitutional rights, including equal rights on the basis of sex, to decriminalize abortion. And this language from Mexico, Supreme Court of Mexico, I think is so powerful. So I just like to share it because I find it powerful and refreshing. So what does this look like at the state level? So 29 constitutions now have provisions explicitly guaranteeing equal rights based on sex. And these vary in their language. Some only protect equal rights based on sex. Others are more expansive and address other common grounds of discrimination. Some apply to private actors. And some of this variation is attributable to when these amendments were passed. ERAs have actually been present in constitutions since the late 1800s. Wyoming and Utah were some of the first places to have ERAs. There were a few states between 2006 and 2010 that adopted kind of regressive versions of ERAs that were designed to limit affirmative action. But more recently, if we look at the ERAs passed in states like New York and Nevada after the Dobbs decision, they're very comprehensive. They cover a wide range of types of discrimination. In New York in particular, it builds reproductive rights into its framing of equal rights, which is a pretty powerful approach. So again, I just want to talk a little bit about how these have been used in US states, and I'm going to go a little bit in sequential order here, just looking at trends and cases over time. So a lot of the early cases with ERAs in like the 1970s, a lot of them dealt with family law, things like marital property, obligations to pay child support, who could take deductions for dependents. And I think these reflected in part some of the more overt discrimination in the law that was present in a lot of places in the 1970s in the US. But I also think they're interesting because they show this sort of this subtle interrogation of gender norms around work and caregiving and the value of unpaid labor, that the ERAs in those states facilitated. You also see ways that state ERAs have expanded states' protections against pregnancy discrimination. And this is notable. Some of the other lawyers in the room may know there was a Supreme Court case in the 70s called Goodell-Dake versus Aiello, where the court basically said pregnancy discrimination is not sex discrimination, so it doesn't get the same level of judicial review. That upheld the exclusion of comprehensive pregnancy care from an insurance program in California. But we see now in states that have passed ERAs, in Colorado, there was a decision kind of reaching the opposite conclusion about their state health insurance. There's also decisions from California and Louisiana that have strengthened protections against discrimination for pregnant workers in both the public and the private sectors. So these examples kind of provide an example of how equal rights provisions at the state level can raise the floor of what's provided by the US Constitution. One of the big areas of litigation with state ERAs has been state-level Hyde amendments, which, for anyone who doesn't know, are state prohibitions on the use of state Medicaid funds for abortion care. So there have been a number of states where gender equality provisions in the Constitution have been used to invalidate these bans. Most recently, it was Pennsylvania, which is kind of notable because they overturned a prior ruling with the opposite holding. But it is important to note that these cases haven't universally been decided this way. So in Texas, the court basically said, you know, this isn't sex discrimination. We don't buy that this is just sex discrimination because it wasn't, the purpose is not to discriminate based on sex. So I highlight that just as a reminder that these provisions can be powerful tools, but they don't necessarily guarantee a specific outcome. And another place where that is true is equal rights on the basis of sexual orientation and gender identity. We look at courts across time and across different jurisdictions have taken different approaches to whether state constitutional language around sex is a basis for addressing discrimination based on sexual orientation or gender identity. So just a couple examples, Hawaii and Montana are two places where the courts upheld the rights of same-sex couples based on the sex provision in the Constitution. But you also see other rulings from other states during the same time period where their ERAs were not accepted as a rationale. And more recently, we're seeing similar divergence when it comes to gender-affirming care. So there was a ruling from Ohio where the judge said a bill that banned gender-affirming care did not violate equal rights based on sex in the Constitution. Whereas in Montana, a ban on gender-affirming care was ruled to be discrimination. It was basically determined it was discrimination based on transgender status, which was itself a form of sex discrimination, violating the state ERA. So finally, this brings me to Vermont. So this is the text that was adopted or approved by the legislature in 2024. And Carrie, correct me if I'm wrong on the procedure, but as I understand it, to become part of the Constitution, it would need to be approved again in the next session and then would go to voters as a 2026 ballot initiative. I'll just give you a second to read it if it's new. So from a comparative perspective, there are a few notable things I would highlight about Vermont's proposed ERA. The first is does have a relatively comprehensive list of grounds of discrimination that would be prohibited. That said, it doesn't include some common forms of discrimination like age, pregnancy, marital status, caregiving, socioeconomic status, which we know are covered elsewhere. It's not impossible to do that. It also doesn't include any sort of catch-all language to indicate that this list is not exhaustive, which a growing number of constitutions globally do, and which can be important just to make sure that we're offering the strongest protections we can. That said, it does include an does explicitly address sexual orientation and gender identity, which I think is really important as we're seeing this inconsistency in how sex provisions have been used in other states. They can be really valuable as tools, but I don't think we can count on them to extend full protections across sexual orientation, gendered identity. Vermont's ERA also accounts for past discrimination, which is notable if you're familiar at all with Supreme Court rulings around racial discrimination and the way the Supreme Court's interpretations have evolved around how much we care about historic discrimination and ruling on equality. One thing it doesn't do is explicitly address disparate impact or indirect discrimination. And it also doesn't extend to the private sector. Generally, constitutions do not, but there are state constitutions where the equal rights provision covers private employers, sometimes even private individuals. So much of what will happen with the state ERA, I think, depends on how it's used and how it's interpreted. Again, these are tools. Constitutional provisions are tools. But, we've seen at the federal level how the Equal Protection Clause has become really diluted over time. It only applies to intentional discrimination, which is very hard to prove. There are types of discrimination the court doesn't even recognize from an equality perspective. So LGBT rights, for example, have mostly come in under the right to privacy, just like abortion has, which is just fundamentally different than a right to equality. So states and advocates that are applying their ERAs are really going to determine what they can do. That said, I think the text of Vermont's ERA is really set up to address some of these pitfalls. There are also resources out there to help ensure that state ERAs truly advance their intent and their potential. The ERA project at NYU Law School has created this whole toolkit about this. One of their proposals is to establish an oversight body to robustly interpret and implement state ERAs. Just to wrap that up, I just want to note also that constitutions are important in terms of their expressive value. So it absolutely matters how people can and do use their constitutions, but it also matters what they say. What they say communicates something about the values of the state, values of the country where people are living. And that can have an impact on norms and expectations and on people's ability to hold their governments accountable when they're betraying those values. So California is one example of a state where courts have taken the ERA as guidance for public policy, which has allowed it to have impact even beyond discriminatory state action. There are also examples from other countries where after a national leader said something that was clearly discriminatory, there were protests in which people invoked equal rights protections in the Constitution to push back. And one that I like to highlight was from South Africa, which was the first country in the world to protect sexual orientation in its constitution in 1996. And in 2006, the president at the time, President Zuma, made some really disparaging remarks about same-sex marriage at a public event. And activists and other government leaders just very quickly condemned his remarks by reference to this constitutional provision. And within a couple of days, he publicly apologized. And he said, our Constitution has this protection. And please feel free to reach out to me with any questions or comments. And thank you so much.
Thank you so much. We have a little bit of time for questions, and I will. There's one right there. I'm not going to run the microphone, right? You all will do that?
Yes.
Okay. I will. Then I'll put this down and stop acting like I'm in charge.
No, I think this is coming through. So if you have any questions, oh, we have a question. And so I'm just going to ask the panelists to repeat your question into their mic so then the online folks can hear it. I do have one online question, but we will let you go first. You could, yeah, you can come forward. That would be, if you are open to it, sure. Nope, that's totally fine.
Sorry, I'm Sarah. I think it's for Jessica, but I also just wanted to say that my son works at that one of those McDonald's, and he went through a lot of sex harassment training, and he told me about it like in his first couple days. So I thought that was good just to say that out loud. Um, my question's about Plan B. And it seems like it's like under lock and key and really hard to access if you're under age 18. And wondering if that's true, the pharmacies that I've been trying to access that from, and also how it just doesn't align with sort of the values of some of the other laws where young people can just go get that. So just wanted broader access to Plan B, honestly.
Yeah, that's a great highlight, and something we talk a lot about. Plan B is available by prescription or over the counter, to anyone who needs it at Planned Parenthood health centers. So that is an option. The state has a harder time mandating what independent pharmacists can or have as part of their supply and stock. So, but we have it if anybody needs it. And the caveat I like to talk about when I talk about Plan B is that Plan B is only effective up to 165 pounds. And so there are other emergency contraceptive options that are more efficacious in some circumstances. And those can all be obtained by an appointment at Planned Parenthood or another family planning provider.
Thank you. And I had no idea that Plan B was only effective up to 165 pounds. So thanks for telling us that.
I know. I feel like that's something that should be shouted to the rooftops because folks are talking about stockpiling Plan B and making sure you have it. And it just doesn't work for the vast majority of our populations.
Wow. Okay, so this is a question from one of our virtual viewers. Many teachers, mostly women, are becoming disabled by long COVID, and some are losing their jobs after requesting accommodations. How can Vermont strengthen civil rights protections so educators aren't pushed out of the workforce when they become disabled? I am an early educator, licensed teacher. My 30-year career ended with one COVID infection.
I can answer a little bit of that, but then maybe Carrie can talk about any legislative thoughts. First of all, I'm sorry that this person has experienced that. I think I can remember in the early days of COVID, we had a lot of conversation with our federal counterparts about whether COVID could either be considered a disability under the law. We've come a long ways on that in terms of, I think, especially long COVID and the resulting limitations on major life activities. It's fairly established that it is a disability in the context of employment laws for most people who experience long COVID. I also want to acknowledge, I'm the daughter of two public school educators who both had to retire post-COVID early because of the complications around schools and COVID. So it's a really complex scenario. I think that in the legislative realm of things, paid leave is a huge thing in terms of not just family leave, but for those experiencing illness. And I think we need to do better in that realm. But it's, any situation like that is incredibly challenging, and forgetting the actual point of whether there was a particular point of the question, how can we be better?
How can Vermont strengthen civil rights
Yeah.
protections so educators aren't pushed out of the workforce when they become disabled?
Yeah, I mean, that's a particularly tough one, I guess, in light of the where you need to be an educator, right? It's generally going to be an in-person type of job that requires a level of engagement that can be really tough if you're struggling with any sort of disabling condition or any other mental health or whatever it may be. I don't know if anyone else has any thoughts.
I don't have any particular expertise in this, but I will say that the question about accommodations and access to the workforce for people with disabilities of any kind is one that is constantly evolving, needs to be. We're learning more and more about long COVID, more and more about the things that get in people's way of being able to do their job, that maybe there could be accommodations for that aren't necessarily addressed by the law currently. And I'll just say, as a state employee, we have been told that we need to return to work in our offices. And there are lots of state employees who have spoken up and said that, for me, working in a cubicle type environment is pretty much impossible. And it's not something that appears on the list of disabilities that are protected under the law. And long COVID is another one, or autoimmune disorders, people who feel like it's just not safe for me to be working in that kind of environment, but it doesn't necessarily qualify as a disability. And so I think that's something that we need to be really looking at much, much more carefully.
Do we have any other questions from the live audience? Nate, do you want to come up?
Thank you all so much for being here and sharing your expertise, first of all. I think my question is mainly for you, Alita. When you see in your studies in global research, when you see these other countries kind of implementing these ERAs constitutionally, I'm wondering kind of if you've noticed a common catalyst for that implementation, kind of getting that process started. Is it often through case filings in their judicial systems, in that country's judicial systems? Is it through broader social movements? I guess, is there kind of one specific thing to point at? And I guess my follow-up is kind of, where do you see the United States in that realm right now? And then I guess, what can we do to kind of start getting the ball rolling a little bit more too with that kind of stuff on the state level or nationally? Thank you.
Yeah, thank you for that question. I think it's a really interesting one that's really about, how does change happen? How do these changes happen that we all really care about? And I think globally, when we've looked at examples in different countries, usually there are many different things happening at once. So when we've looked at changes that have happened in South Africa, there have been. I'll give you one example, because another area that we work on a lot is paid leave, and the campaign to get 10 days of leave passed for fathers in South Africa was kind of a big deal. There aren't that many. There's still too few countries that provide specifically for fathers, so it was a big landmark. But that happened because a lot of groups came together. There was an individual father who didn't get paid leave after his premature twins were born, and he started just writing letters, and he became an activist, and he started, reaching out to every member of parliament who would be willing to hear from him. And there was a labor union that was very active and played a really foundational role. And there were also international organizations that were providing some of the research and that global context that can be compelling for policymakers if they see, your neighboring countries are doing better than you on this. So I think in that case, and in many, we see it's a lot of different types of activity all happening at once. I do think social movements are crucial. I think everything ultimately comes down to having strong social movements. But whether the actual mechanism of change is litigation or more sort of negotiation, I think that can really depend on the specific context. So, I mean, in the U.S., I'd be interested to hear what everybody thinks, because I think there's so much really important strategic thinking that needs to happen. I don't think this is the time to try to litigate everything. And just going back to the overall ERA piece, there's sort of a movement now of people who think that, the federal ERA is part of the Constitution. It has met all the requirements. The only thing that hasn't happened is it being formally published. There is an advocacy movement that's saying this is the 28th Amendment, and we're going to move forward with it as such. And I totally get that. And I also recognize it's not a political reality. And I would not want this Supreme Court, interpreting the ERA, even if it is part of our Constitution now. So, yeah. Do you guys want to add anything on strategy?
I can't speak to the ERA, but you said something that I think actually related back to the first question that is important to touch upon in terms of like grassroots movements. And so one of the things, there's been expansions that came into effect this year in the Vermont's Parental and Family Leave Act. And one of the things that I thought for sure would happen as part of that So for those of you that aren't familiar with those leave laws, in order to even get unpaid leave for up to 12 weeks, you have to work a certain amount of hours in the prior year. And for many folks who work in schools, not necessarily teachers, but a lot of support staff, they're contracted for less hours than meets that leave requirement. And so they don't actually always qualify for those leave protections. There may be some policies in their school district, but under the law, they're not necessarily protected. So I thought for sure last year, not to call them out, but the NEA or any other sort of advocacy group would come in and fix that. They didn't, but who did come in were the pilots associations, the airline pilots associations, because they also work wonky hours. And so now in our state leave laws, we have a protection for, is it pilots or folks who work on airplanes? I think it's pilots specifically. But teachers, there's still a gap there. And so being present in the room matters, like being advocacy matters, especially I think in our small state, in terms of we have to kind of get in there and protect each other and advocate for those who may be falling through those gaps.
I'll just say that you just added something to our to-do list for for when we're thinking about what's next and collaborations, and which is a big theme of this whole conference. And so I know we're pretty much out of time. So I will stop there, but thank you so much to our panelists, and thank you all for being here and asking such great questions.
Thank you.